Hey everybody. So today I'm going to be going over some immigration news updates. I'll hit on three topics that have recently been in the news, and I'll try and clear up some rumors about those because I'm certainly getting a lot of calls that um, have a lot of wrong information in them. A lot of people are seeing things in the news and thinking things that aren't true, or some people just don't know what's going on. So I'm going to try and clear up some of these, and feel free to comment with your questions. You can comment in Spanish or English. My assistant is here to help me with the Spanish part of this. If any Spanish speakers want to ask questions, we'll answer those at the end of the segment. And I have got some English speaking questions to address at the end as well. So as far as immigration news, one of the big things that we've been seeing in the news recently, and what I've been being called a lot about, is what immigration lawyers refer to as the 10-year myth. This is a persistent belief that has misled a lot of people over the last decade. People thinking that because they have been here for 10 years and they have a U.S. citizen relative, usually one with special needs, they think that that is somehow a way for them to get status in the United States. Unfortunately, this is not true for most people. They're referring to a form of relief known as cancellation and removal. And while this has been in the news recently, this is only a form of relief that's available to people that are actually in removal proceedings, where most people don't want to be in immigration court. And the reason that this has been in the news is because in June, the Supreme Court in Pereira v. Sessions, forgive my pronunciation, the Supreme Court issued a decision that basically gives a lot more people the ability to apply for cancellation and removal. Please note, though, that you still have to be actually in removal proceedings to take advantage of this. So under cancellation and removal, you have to have 10 years of continuous presence in the United States, and you have to prove each one of those years that you've actually been in the United States for those years. You also have to prove a number of other things: hardship to family, and that you have a person of good moral character, or a lack of criminal record that could disqualify you from that. So before the Supreme Court case, somebody who applied for cancellation and removal, I'll use an example to keep it as simple as possible. So say somebody gets picked up by ICE and they're issued a warrant. This is called a notice to appear. I'll refer to it as a warrant simply for ease sake. So somebody's picked up by ICE and they're issued a warrant, okay? This warrant is supposed to say on it, okay, this is the time and date that you're supposed to appear before an immigration judge to go over your case and see if you're eligible for any form of relief. The problem is that the Department of Homeland Security has been issuing thousands of these notices to appear, warrants, without the date and time specified at which the non-citizen is to appear for their removal proceedings. And this was the challenge that was taken up to the Supreme Court, because somebody who didn't necessarily have that 10 years of presence before they were given a warrant wanted to apply for cancellation and removal. And he argued that because the warrant didn't contain the date and time that he was supposed to appear in immigration court, that it couldn't cut off his time period that would make him eligible for cancellation and removal. Okay? So if somebody's picked up in ICE in, say, 2015, that would mean that they're likely still in removal proceedings today due to the immense backlog of cases that is in immigration court, 700,000 plus cases. So say somebody's picked up in 2015 and they're issued a notice to appear. This notice to appear is tells them to come to court, okay? So before the Supreme Court case, let's assume this person that was picked up in 2015 had been here since 2008, and they could prove their presence from 2008 to 2015. That's a problem for them because they aren't eligible for cancellation of removal, or weren't before this June, because the 2008 period, or the 2008 to 2015, is only 7 years, can't apply for cancellation of removal. Well, the Supreme Court has held that those notices to appear that don't list a date and time to appear in immigration court don't stop the time that somebody is eligible for cancellation of removal. So that means that this person who is in removal proceedings since 2015 and wouldn't have been eligible for cancellation of removal before due to the lack of presence is now eligible to apply for cancellation of removal because now they have 10 years of presence. So it's 2008 to 2008 to 2018. That's 10 years of presence. So this person's now eligible for cancellation. So this is a great thing for people that are actually in proceedings and are actually eligible for cancellation of removal besides the presence, i.e. They've got US citizens with hardships and they don't have an extensive criminal record or no criminal record at all. I have gotten a lot of calls from people asking if I can put them into removal proceedings simply for the purposes of applying for cancellation and removal. I think this is a very bad idea. And I'll tell you why. Cancellation of removal is only available to 4,000 people a year. That means immigration judges are only able to give out 4,000 grants of cancellation of removal per year. If, for example, I were to win a cancellation of removal case in immigration court today, they've already given out the 4,000 cancellation of removal grants, mostly to people from last year. So people waiting on cancellation of removal that have been approved can't actually get the grant of cancellation of removal until next year. So there's a very small number of cases that can actually be granted cancellation of removal. And given that 700,000 plus people are in removal proceedings, 4,000 grants of cancellation removal does not go very far unless, of course, Congress acts to make more numbers for that. Because of the number of people that are eligible for cancellation removal the number of people is much higher now due to the Supreme Court case, the standard that somebody has to meet for proving hardship to their relatives is likely now to grow much stronger and much harder for a person to prove than it was before. And so that's going to be a real problem. A lot more people are going to be losing cancellation cases. So it's a good thing and a bad thing that we now have more people eligible. But it does make people who were already eligible, who had the 10 years of presence, regardless of the warrant lacking a date, could potentially make their cases less likely to be granted, whereas before they might have been granted more easily. Immigration judges are going to be looking at these cases with a fine-toothed comb. They know that they can only grant a certain number a year, and so they are going to, I imagine, start granting less and less of these cases. So it's not a good idea to want to be put into removal proceedings. Maybe perhaps if you had an amazing case that was be a slam dunk, but there is no slam dunks in immigration court. But I just don't think it's a good idea. So you can ask me any questions about cancellation of removal. If you want to send me a message or call my office, there are some people that I've talked to who are in removal proceedings who are now eligible, and we will be applying for cancellation and removal for them. So if you think you might be eligible, talk to your immigration lawyer or contact my office, and we'll try and help you out as far as sorting out your eligibility for anything we can help you with. So the next thing I'm going to talk about are some recent changes in United States asylum law. And this has been in the news. It's not in the news as much as it probably should be because it's a little bit confusing to a lot of people. But immigration is a hot topic right now, so we have seen some of it all over, CNN and whatever news outlets you watch. The big change in asylum law that I'm going to talk about is a case that Jeff Sessions, our Attorney General, put out this summer called Matter of AB. This case basically says that people who were victims of domestic violence and gang violence are no longer, under most circumstances, eligible to apply for asylum or be granted asylum. The opinion says that really any sort of crime that is inflicted upon a person by a private actor, which is somebody that is not the government, doesn't make a person eligible for asylum unless the government was assisting the person in inflicting harm on someone, or if the government acted in collusion with the private actor who has inflicted harm on the asylum seeker. So to keep it simple, I'll use an example. So let's say we have a woman from Guatemala who is married, and she's in an extremely abusive relationship with her husband. Her husband keeps her locked up. Her husband beats her. He sexually assaults her on a regular basis, degrades her, withholds food, any kind of torture, any kind of physical abuse. That is a problem. Okay, so let's say she tries to escape. She moves to her sister's house 2 hours away. He finds her, takes her back home. She's back where she started. She goes to the police. The police say, like they do frequently in Central American countries, that they're not going to get involved in relationships between a man and his wife. Very typical. So that woman makes the journey to the United States, somehow escapes, comes here, applies for asylum, and ordinarily, before this most recent decision, she would have been eligible for asylum, even though it was her husband inflicting the harm and not the government. Now, domestic violence and any sort of violence that's inflicted by a private person doesn't really qualify somebody for asylum anymore. It's gotten much, much harder to get asylum if there's any kind of privately inflicted violence. And it's getting harder also for people to even get their asylum claims in front of an immigration judge. So when somebody approaches the border at a point of entry, say in Texas, and they go up to an officer and they say, I'm claiming asylum. Well, they'll usually be detained and they'll be given the chance to speak to an asylum officer about their claim. This is called a credible fear interview. Now, what used to happen was they would talk to the asylum officer, go through the credible fear interview, and if the asylum officer decides that their fear of returning to their country is credible, valid, then they would basically issue them one of those warrants, the notice to appear, to go to immigration court so that they could put their case in front of a judge, because the asylum officer at the border doesn't make the final decision. Well, now asylum officers at the border have been told that to either outright reject claims involving domestic violence and gang violence, or to just simply not even hear them. They can just deny them and turn people around at the border. So we're likely to see a lot less people coming in asking for asylum. A lot of people that come from Central American countries, which is most of what I deal with, they are battered and abused women and children. And now those people do not really have much of a shot at asylum unless it was the government inflicting harm upon them. So it's a really bad change in the law. It is being challenged, and it's going to go up to the Supreme Court, I'm sure, because there's going to be a lot of lawsuits happening about it. A lot of people are upset, and it's for good cause. I mean, Jeff Sessions has single-handedly changed asylum law as we've known it for the last 5 years. So that's something that we should all keep in mind and keep an eye on the news for updates about. So the third thing, the final news update that I'm going to talk about is a recent guidance memo that was given from the Department of Homeland Security to USCIS officers. So USCIS officers make decisions about people's petitions for relief outside of immigration court, like family petitions, U visas, VAWA, waivers, anything. I mean, everything. Naturalization, green card applications. They're the ones that make those decisions. Now, before this guidance memo came out, if somebody was denied a petition at the USCIS level, so let's say somebody applies for, they apply for a hardship waiver so they can get their green card through their spouse. If that waiver was denied before, it wasn't customary for for that person who applied for the waiver to get sent to immigration court for removal proceedings. Now, USCIS officers have been instructed that they are to refer all denied petitions to immigration court for prosecution and removal proceedings. So somebody, we used to think that applying for something like a U visa was no threat to anybody's status here in the United States, because if it was denied, it was simply denied. They would just remain undocumented and would not be in ICE's radar. This is a problem now because, if somebody's, say, U visa petition is denied, they are most likely going to get issued a notice to appear in immigration court. So that's a big problem for people today. And it's going to make a lot more people scared to submit petitions to USCIS. It's definitely going to make people scared. They're not going to, it's hard to convince somebody to submit anything to immigration with their address on it right now, knowing that if this petition gets denied, if I take this risk, I might ultimately be removed from the country, separated from my family, and it's not good. So I don't think that all denied cases will be referred to immigration court. There are over 700,000 cases pending in immigration court. And, we have it's a huge backlog. Court dates are being set 5 or 6 years out. There's no way that they can possibly handle all of these cases coming from USCIS from people with no criminal history who have applied for a benefit from USCIS and gotten denied. I don't think we'll see a ton of referrals, but everybody needs to know that that's definitely a risk that we have to address now. So I asked for some questions on my Facebook page, and I've gotten some through email, and I've gotten some through my Facebook messages. Feel free to comment with some messages, or comment with messages or in the comments. I'm going to go over this first question, which has to do with a deported spouse. So this question says, I am a citizen and my spouse was deported once several years ago. He then tried to re-enter the country and was caught and deported again. Hold on. He was caught and deported again. He had been over here for over 15 years before he was deported, and we have U.S. citizen children together. What can I do to fix his status and get him back into the country? So the problem here is not necessarily the deportation order. That's certainly a problem. It's still a complicated situation. The problem here is that this person entered the country illegally once. They stayed for over a year illegally, went back out of the country, i.e. deported, and they try to come back in again. When this happens, people are subject to a permanent bar from the United States, meaning that they can't get a green card through a spouse, can't get really any immigration benefits. The only way to get around that basically would be for your husband or spouse or wife, whatever, to wait outside the country for 10 years, and then they have to apply for permission to reapply for their immigration benefit. So that's an unfortunate situation. Most likely, if you give me a call if you want an appointment so we can talk about it and see if there's any exceptions that apply. But it sounds like he's gonna have to wait outside the country for 10 years before he can apply for permission to re-enter the United States and get his green card through you as the U.S. citizen spouse. So the second question is about an investor visa, either an E2 visa or an EB5 visa. This person says, I want to get an investment visa to come to the United States by investing in a restaurant, but I'm a licensed engineer in my home country and I want to work with a company that has offered me as a job as an engineer but won't sponsor me for a work visa. Could I invest in the restaurant, get the investment visa, and then work with the company as an engineer once I get into the United States? No, you can't do this. The purpose of the investment visa is for people to invest in the United States, create jobs for United States workers, and then allow that the person to enter the country and control and develop their investment. they can't just invest in something and sit back and work wherever they want, do whatever they want while they're here in the country, and allow their investment to go without their oversight. So if you're going to invest in a restaurant, you better have some kind of managerial role in that restaurant, and you cannot be working for another company. That will violate the terms of your status, and you likely wouldn't be able to renew it. You could also, of course, get put into removal proceedings if they deny or revoke your status as an investor. Okay, so this third question is from an individual from Honduras that has TPS, that's temporary protected status. This was given to Hondurans back in a long time ago. I don't remember the exact year, because of Hurricane Mitch heavily destroying Honduras and creating a lot of refugees coming to the United States as a result of that. So the question is, I have TPS from Honduras and I have a 22-year-old US citizen child. Can I get my green card through my child? Well, ordinarily, if you have an illegal entry, which TPS holders typically do, if you have an illegal entry and your child petitions for you, you can't technically get a green card from it because of the illegal entry, and there's no waivers available for that. However, if you live in Tennessee or anywhere in the Sixth Circuit, and even in some other circuits around the United States, if you live in Tennessee, the Sixth Circuit has held that a grant of TPS to somebody essentially acts as a lawful admission for purposes of adjusting status. So if you live in Tennessee, it's fairly simple. It's still a lot of paperwork, done several of these. Your child would file a petition on your behalf. Because you are the parent of a US citizen, you are eligible to file your green card application at the same time they file their petition for you. So you file the petition, you file your green card application, you provide proof of your TPS status, and the TPS acts as a legal entry. So because you have that visa available for your child, and then you've got a quote unquote legal entry, you could get your green card that way. So that's definitely a really great way of getting status, especially if you live in Tennessee or in a couple other states. So definitely call my office or message me if that's something that you're interested in. We don't know how long these laws and case law are good for anymore. As you can tell from my earlier news update, it's kind of crazy and things change quickly. So I'm going to go over to my comments. I think I have some questions in there. Okay, so somebody's asking if there's any changes to the U visa program. No, there's not any changes to the U visa program other than the fact that if your U visa is denied, you might get put into immigration court for removal. But there has not been changes to the U visa program itself. U visas are great. They used to be a really sort of quick, easy way to getting a green card. Not so much anymore because, like cancellation of removal, Congress has capped the grant of U visas to 10,000 a year. Right now, there's over 100,000 people in line waiting for a U visa to become available. So if you apply for a U visa now, I'm telling people expect to wait 8 to 10 years before you get any kind of work authorization or any kind of benefit out of it. That's not saying you shouldn't apply. You should still apply because, who knows, they could do away with the program altogether and then you'd be out of luck. So it's still a good idea to apply regardless of the backlog. Somebody's asking my office hours, Monday through Friday, 9 a.m. to 5 p.m. I am available after hours for some consultations. Just message me and see if I can make that work. And if there are special circumstances, we can try and make arrangements around your schedule. So just give us a message or a call and we'll see if we can get you taken care of. Okay, so Miss Yannick here says, is it true that if you are the parent of a U.S. citizen child, you still get penalized for 10 years and that you're not qualified for the waiver? That is still true. If a spouse petitions for a spouse, as long as you're the spouse of a U.S. citizen, you're qualified for a waiver of that 10-year ban that you're talking about. But parents of U.S. citizens cannot get that waiver through their children. So if your child petitions for you and you have an illegal entry and the 10-year bar, then you're not going to be able to do anything to get your green card unless there's some kind of exception in your case, which there might be. That's certainly something we can help you with if you want to call and make an appointment. Jessica. So talking about the guidance for referring things to immigration court, the question is, does the guidance only look forward or does it look back as well? I.e., I filed a U visa petition in 2016 and it's still pending in July 2018. Can it be referred to court? I read the guidance memo and it doesn't really, I don't think it addresses retroactive application. I imagine that any petitions, regardless of when they're filed, can be referred to immigration court. That's just what I got from the memo. So, you know, I too am nervous about some of my older U visa cases that I filed in 2015 and 16 that have not, nobody's made a decision on yet. So here's this is kind of a complicated question. I kind of addressed it earlier. If somebody's been deported, can they come back in? The answer is in some circumstances. You have to have a qualifying relative to get back into the country to petition for. You have to have a visa available. And then if you have a deportation order, you have to, like I said before, you have to apply for permission to reapply to come back in the United States. So that's going to be an issue. It's very complicated. That's definitely something you should talk to a lawyer about if you don't have one already. And they can try and help you out more on that in ways that I can't on a Facebook Live video. Okay, and let me see if I have some questions in Spanish. Okay, so we don't have any questions in Spanish. I'll probably start doing one of these every week, probably every Thursday at 4, since there's so many changes to immigration law. If you have any questions, feel free to message me at any time. I'm pretty good at responding to messages, though I do get a lot every single day. And I do free consultations. So tell anybody that you know if they need help, I'll talk to them. I won't charge them for it. And we'll see what we can do for them. And thanks for watching.